It is not uncommon for managers of criminal justice personnel to receive complaints alleging on-the-job discrimination. Whenever discrimination is based upon an employee's status as a member of a protected class, it becomes illegal. Thus far, race, disability, national origin, and gender have been recognized by courts as belonging to a protected class. Federal and state statutes, as well as Title VII of the Civil Rights Act and the American Discrimination Act, among other laws, including the Equal Protection Clause of the 14th Amendment, provide a safeguard against on-the-job discrimination. Employees may argue that they have been victims of disparate treatment, which means that they essentially allege that they have been signaled out and treated less favorably than other employees on account of their race or any other type of protected class. Since most employers will rarely admit to having discriminatory motives, it is often difficult for a plaintiff to find direct evidence of discrimination. Therefore, evidence of discrimination tends to be circumstantial in nature. Let us suppose that an employee does not get a transfer which was requested and believes it was solely due to his or her race. If the employee wants to file a lawsuit, 4 things need to happen for the employee to show evidence of a case of possible disparate treatment. First, the employee must demonstrate that he or she is a member of a protected class. I think it's worth noting that an employee of any race may file a lawsuit of this nature, since race is a protected class regardless of whether a plaintiff is a Caucasian, an African American, a Hispanic, or of another race. So a white male may file a reverse discrimination lawsuit in this case, and he may indeed be successful. Once the plaintiff has demonstrated that he or she is a member of a protected class, the employee will need to show that he or she was qualified for the position or transfer in this case that they desired. Next, the plaintiff will need to show that he or she suffered an adverse action. In this case, an adverse action would be not getting transferred. Finally, once the employee has demonstrated all of the above, this must be linked with an inference of discrimination. If this can be established, then typically the defendant, who in this case would be the employer, would have the burden of producing evidence that the plaintiff was denied the transfer for legitimate, non-discriminatory reasons. For example, a supervisor might decide not to approve an employee's request to transfer to another shift solely because of budget concerns, which would definitely be legitimate, non-discriminatory reason. Often, disparate treatment cases come down to whether or not other employees who have been treated more leniently were similarly situated. For example, a Hispanic employee might file a grievance against a criminal justice organization alleging that a Caucasian employee was given preferential treatment. Say, for instance, that both employees requested to be transferred to another shift, and the Caucasian's request was granted while the Hispanic's request was denied. While this may look like blatant discrimination, the employee must be similarly situated with the other employee for discrimination to have actually occurred. If in this case the Caucasian had worked for the agency for 5 years longer than the other employee, then he or she may have been given the transfer because they had seniority over the other employee. Racial and sexual harassment are ugly cousins of discrimination claims and are by all means a reality within most criminal justice organizations. Nevertheless, today it is extremely rare for a law enforcement officer to prevail in a harassment lawsuit. For now, let us consider sexual harassment, which certainly occurs in justice organizations today. Before we begin, let us distinguish between the 2 types of sexual harassment. First, there are the so-called hostile work environment claims, where here the plaintiff alleges that the workplace is inappropriately tolerant of sexually offensive behavior. For example, if an employee displays inappropriate sexually explicit pictures in his cubicle, this may indeed constitute a form of a hostile work environment. Next, there is the classic quid pro quo form of sexual harassment, where a supervisor tries to compel a subordinate to grant sexual favors and in return offers to advance the employee's career. Interestingly, this type of behavior may also create a hostile work environment for coworkers. In the wake of the 1998 U.S. Supreme Court case On-Call versus Sundowner Offshore Services, it has become much more difficult for an employee to successfully sue an employer for harassment. The reason for this is that in this case, the court held that only behavior on the part of the employer which is so offensive as to alter the condition of the victim's employment will be likely to help the plaintiff prevail in a civil suit. So as a result of the on-call case, courts have rejected harassment lawsuits unless a plaintiff can show what is referred to as an adverse employment action. The vast majority of cases of sexual harassment do not involve adverse employment action. So this essentially is a very difficult hurdle for plaintiffs to jump. However, a plaintiff can quit and argue later that a constructive discharge occurred. In other words, the work conditions became so intolerable that any reasonable person would have felt compelled to resign. Finally, today, so long as an employer has a sexual harassment policy in place and makes some effort to stop any harassment, there is unlikely to be any liability for sexual harassment of the hostile work environment variety. So the court has gone out of its way to protect employers from liability for harassment claims. Let us turn our attention now to religion in the law enforcement workplace. In recent years, employees have sued their employers alleging that grooming codes or work schedules which conflicted with religious beliefs. A remedy is available under the First Amendment's Free Exercise Clause, which prohibits the government from restraining or burdening individuals in the exercise of their religious beliefs. Generally, in order for a law enforcement officer to show that he has been discriminated against based upon religious beliefs, he must first demonstrate that he has a bona fide religious belief which conflicts with an employment duty. Next, the employee must make an effort to inform the employer of his belief, letting him know that this conflicts with his job-related duties. This essentially gives the employer an opportunity to make an appropriate accommodation if possible. However, if on the other hand the employee alleges that the employer either threatened or subjected him to an adverse employment action, which could include a constructive discharge, then there is a viable case. The burden will then fall on the employer to show that either an accommodation was made or that accommodating the employee's religion would result in an undue hardship. Generally speaking, even if an employment practice poses a hardship on an employee's religion, as long as it is based on legitimate operational reasons, it is likely to withstand challenges in court. For example, suppose a law enforcement officer is a Sunni Muslim who desires to grow a beard in conformance with his religious beliefs. Generally speaking, courts will allow the employer to enforce grooming codes even if this might conflict with an officer's religious beliefs. However, what gets managers of criminal justice personnel into trouble is when they make accommodations for other types of employees while ignoring the wishes of the officer who is a Sunni Muslim. If, for instance, supervisors permit officers to wear beards for medical reasons, it is very likely that there will be liability if they are unwilling to make exceptions for officers who wish to grow beards for religious reasons. It is worth mentioning that a law enforcement organization does not need to accommodate every religious request of every employee. Courts have found that if an employer would suffer an undue hardship, an accommodation does not need to be made. Let's suppose that the Sunni Muslim officer wanted to wear a religious head cover while on duty. This request would most likely be denied on the basis that the law enforcement organization had a pressing need to promote uniformity among its officers. The courts have held that if individual law enforcement employees were permitted to significantly alter their appearance based upon their religious beliefs, this could create divisions within the organization. Also, it might be difficult for citizens to recognize who is actually a law enforcement officer and who is not. So for this reason, a manager of police officers is usually free to order his or her subordinates to refrain from altering either their uniforms or appearances, as this may provide an undue hardship for the organization. Having said this, it is likely that if a law enforcement organization is structured in more of a civilian manner, as opposed to being structured along quasi-military lines, then employees will have more freedom in regard to religious expression. For example, wouldn't it seem logical that a probation officer should be permitted to have a beard or wear a religious head cover during the course of his 8-hour shift? After all, this employee is not constantly coming into contact with the general public, and it is really not necessary for probation officers to wear uniforms, and they very seldom, if ever, do. Besides looking at grooming standards, there are other important issues to consider which are related to religion in the law enforcement workplace. For example, let's suppose that a Roman Catholic police officer was scheduled by his superior to stand guard in an abortion clinic. Suppose he files a complaint alleging that this violates his religious beliefs since he is helping to facilitate abortion. The court has been very clear on this issue and has held that individual law enforcement employees must be neutral in providing services. As public officials, they owe a responsibility to everyone and must essentially leave their agenda at home when they are on duty. This means that theoretically, even a Jewish police officer can be assigned to protect neo-Nazi demonstrators. As of today, law enforcement employees who refuse to enforce particular laws because of their religion have without a doubt been offered the least amount of protection by the court system.